A question that comes up often for real estate professionals from buyers, especially first-time buyers, but by no means only, is what do they do when they get the questionnaire asking how they would like their property to be vested? It can seem like an unusual or intimidating question. It's not something that we usually have to answer when we're purchasing anything else. There's no vesting option when you're ordering your pizza in the Domino's app, for instance. The closest sort of parallel I can think of in everyday life would be uh, when you're filling out an automobile title, putting either and or between multiple owners and the different sort of implications that that has. But the available forms of vesting seem much more complicated, and to be fair, they are. Uh, so this video is all about the different ways that people can hold title and a bird's eye view of what those different ways of holding title mean in various situations. And a very important note here, the best way of holding title for any individual or any particular situation is a matter of legal advice. That's a legal question for a legal professional, which I am not. I'm not a lawyer. I'm a title sales rep. So this should be looked at as informational only. Like I said, a bird's eye view to give a basic grounding for real estate professionals in these different forms of holding title. But if you need advice for how your property should be vested, the right place to go is not this video, but legal counsel. So please do not look at this video as legal advice or attempt to use it as a substitute for legal advice. In the real estate and title world, when we talk about vesting, usually what we're referring to is who is the owner of a property, who holds title to the property, and how do they hold title to the property. Because, like I've alluded to, there is a variety of ways that a person or a group of people can hold title to a property. And it's a very important decision with big implications for the way that ownership is divided between parties and what happens to your ownership share of the property if you should pass away. And the reason why there are so many is because people can have very different, very diverse wishes and goals when they're acquiring real property for how ownership interests should be divided and how rights over the property should be allocated, and especially what might happen to the property if one or more parties pass away. A great example is just to think of a newlywed couple just starting their life together, buying a home, versus a group of friends buying a property together as an investment. In the first case, with a married couple, you can imagine that they may or may not want the ownership share of one spouse to automatically pass to the other in the event of that spouse's death. But when you're looking at a group of investors who may be friends but not married to each other, it's seems less likely that they would want this kind of right of survivorship built in. It's more likely that if I'm going in on a property with some friends, I would want my ownership portion of that asset to pass to my family if I should pass away. So these different situations would likely use different forms of holding title to express those goals and set those ground rules for the division and allocation of the property. So what we'll be doing is going through the most common ways of holding title in California one by one and just looking at what each form of ownership means as far as the division of interests in the property and succession, what happens if a party passes away. And again, not legal advice. Please, please, please don't hesitate to consult with legal counsel if you need help deciding what form of vesting is right for you. Our first form of holding title to look at is called severalty, which is, it Sounds complicated, sounds intimidating. It really isn't. It's a fancy way of saying actually not several people on title, but one party on title, one person or entity holding title. This can take the form of an unmarried person, single person, a married person holding title as what's called their sole and separate property. Severalty is super easy in terms of division of ownership interest because there are no different parties to divide ownership interest among. Obviously, the owner in severalty has full ownership of the property, full right of use and access to the property. And as far as succession, if the owner of a property in severalty passes away, the property goes to their estate, their heir or devisees, and generally in this case, probate proceedings are required. Next up is community property. And community property is a way of holding title that is only available to married couples or domestic partnerships. And it is, in fact, in California, presumed in those cases unless another way of holding title is actually specified on the deed. And you may have heard California referred to as a community property state. And in real estate and title, one of the things that this means is that that presumption of community property is so strong that even if only one spouse or domestic partner is named on the deed where they acquire title, it is still considered to be held by both in community property unless the other party has expressly and specifically deeded off their interest to create ownership and severalty for the other spouse. As far as the division of rights and ownership interests, everything in community property is shared and shared evenly. So ownership interest is 50-50 between the parties exactly, and rights of use are full for both parties. Succession is a little more complicated, and that will depend on whether or not the right of survivorship is specified on the deed. The form of community property, like I've mentioned, that is presumed does not include the right of survivorship. And in this case, if one of the parties on title as community property passes away, their ownership interest goes to their heirs or devisees, and generally probate is required. But if community property with right of survivorship is named on the deed and one member of the couple passes away, the survivor will hold full title to the property in severalty automatically without requiring probate. Joint tenancy has some important similarities and some important differences to community property, especially community property with right of survivorship. So one of those differences off the bat is joint tenancy is not restricted to married couples or domestic partnerships, although it still is certainly available to them. Any number of people with any relationship to one another or no relationship to one another can be joint tenants on a property together. And ownership interest is, again, absolutely even. So 50-50 if there's only two, but even if there are more, absolutely even ownership shares in the property under joint tenancy. And like community property, all joint tenants have the full right of possession, the right to use and access the property. Succession, very similar to community property with right of survivorship. If one party passes away, their ownership interest is automatically absorbed by the remaining joint tenants. If there have been more than two joint tenants, then it will remain a joint tenancy. If there are only two and one passes away, then the surviving owner again holds title completely in severalty. Unlike community property, it is possible for one joint tenant to dispose of their ownership share of the property independently, to gift or sell their portion of ownership, which breaks the joint tenancy. It's no longer joint tenancy. the person receiving that ownership interest now holds that interest as a tenant in common with the remaining joint tenants. What is tenancy in common? That is our next subject. Tenancy in common may sound in name very similar to joint tenancy, but the differences are striking. Not that there aren't any similarities, like joint tenancy, any number of people can be tenants in common, and right of possession over the property is even. But ownership interests are not necessarily even. They will be presumed to be even if ownership interests aren't specifically divided on the deed. But one of the flexibilities of joint tenancy is that you can actually specify exactly how much interest each party has, usually as a percentage, and the percentages can be very detailed. I'm sure I can remember seeing a joint, or excuse me, not a joint tenancy, a tenancy in common deed with percentages of ownership interest down to the third or fourth decimal place. And it can lead to some pretty complicated vestings. You can start to see other forms of ownership sort of nested into a tenancy in common, by which I mean something like John and Jane Doe, husband and wife, as community property, as to an undivided 60% interest, and John Smith, an unmarried man, as to an undivided 40% interest. And this can, again, be more than two groups, but then at the end it says all as tenants in common. So some of the more complicated vestings that you will see will usually be tenancy in common. As far as succession goes, everything is pretty well separated as far as the different ownership interests. So if the holder of one ownership interest in that tenancy in common passes away, that share goes directly to their estate, to their heirs or devisees, and becomes subject usually to probate proceedings. The different forms of ownership we've seen so far concern natural persons, as we would call them, but title is not always held just by natural persons. Sometimes it's held by a legal entity, such as a company or a partnership or a trust. And the different considerations in these cases is a topic for a video or a group of videos unto itself. But for the purposes we've been looking at here of the division of ownership interests and rights of possession and succession in a property, these are not set by the vesting itself, but by the documentation of the entity, or the bylaws or the trust documents. Trusts especially are becoming very popular as a way to control the succession of ownership without the property being subject to probate. All of these entities must be formed with the help of appropriate legal and professional guidance before they can take title to real property. When a company owns a property, you'll just see the name of the company and the state that they're incorporated in on the deed. But when a trust owns a property, you'll still see the names of the people who hold ownership in the trust listed as trustees of the trust. The deed might, for instance, read Will Gray as trustee of the Gray Family Trust dated such and such date. Hopefully all of this has been helpful in understanding the very basics of these different common ways of holding title in California. In case you haven't been taking detailed notes through my ramblings throughout this video, we have a great resource for you, a PDF chart that lists these common ways of holding title and different ownership scenarios that differ under those ways. In a quick and easy reference, I referred to it heavily in preparing for and recording this video. It's available for you free. You can head over to willfortitle.com/resources to download your copy and check out the other resources that I have available for you. And if you have any questions or anything you'd like to see a video on in the future or read about on my blog, you can contact me anytime. Go to, again, willfortitle.com/contact and find out how to reach me. Love to hear from you. Until then, I'm Will Gray. Thanks so much for watching.